Good morning. We are here today for oral argument in our case number CV220270, Mago et al. Versus Arizona Escrow. Each side has 20 minutes for your argument. The appellate may reserve time for rebuttal. I would just ask that you keep track of that yourself. There's a clock on the podium, on the other side of the podium for that purpose. Our proceedings today are being audio and video recorded, so please introduce both yourself and your client at the outset of your remarks. We have read the briefs, conferenced the case, and are familiar with the arguments raised. So please keep that in mind as you make your arguments. And with that, counsel, you may proceed.
Thank you, Your Honor. Good morning, Your Honors. Roger Cohen on behalf of defendant Arizona Escrow and Financial Corp. With me is my partner, Kathy Sandweiss. Your Honors, the overriding issue in this case, and the one that requires that the case be reversed, the verdict be reversed, and the case be remanded to trial, is the failure to apportion fault to the one party that is absolutely known to have contributed to the loss suffered by plaintiffs. And that is the fraudster, the hacker that he's called. We know this person exists. We don't know who he is, or she, but we know that there is a party there someplace that committed a fraud.
Counsel, the plaintiffs hired your client for the specific purpose of protecting them from the harm that occurred to them. I understand that the purpose of an escrow, one of the purposes of an escrow account is to make sure that money goes where it needs to go, and that's partly to protect against what actually happened here. So how is the fraudster at fault for your client not doing what it was supposed to be doing?
Well, there's a number of different ways to approach that, Your Honor. Number one, the escrow agent is hired generally to handle funds in and out. The specific issue of wire transfer fraud is not a contract issue. It's not something that was addressed at the time Arizona Escrow undertook to be the escrow agent. We have it is not a strict liability issue. The question that was raised at trial and was resolved against our client, and we're not re-arguing that on appeal, is did Arizona Escrow breach its duty of care, fiduciary duty of care, in the manner in which the funds were handled? But that's only the first step. And Arizona has enacted an apportionment of fault statute. And the statute is very clear that you look at the totality of the fault, where there's an indivisible loss. There's only one loss here. That's the money that was wired to the fraudulent account. And the trier of fact is required to look at all parties that contributed to that fault.
All right, so counsel.
Yes, Your Honor.
I think you characterize the statute as pretty clear. And I have it in front of me. The word it uses is that the jury must consider the fault of all persons who contributed to the alleged injury. Is your argument that the word or the verb consider indicates more than it might otherwise reflect in the definition, that you must assess, and consider and assess, or apportion, or does it just say consider, and is that significant?
Yeah, well, Your Honor, the problem there is taking the word consider out of context. That is one word which admittedly the statute does say consider, but the statute also says, the Ogden case says, a jury is not entitled to completely disregard the fault of a non-party.
The Ogden or the, I mean, right now we're with the statute, right? That's the law.
Okay, the law,
Yeah.
sorry. Okay. So the law says the relative degree of fault of the claimant and the relative degrees of fault of all defendants and non-parties shall be determined and apportioned as a whole at one time by the trier of fact. Above that, this is in subparagraph A, it says that in an action for personal injury, property damage, or wrongful death, the liability of each defendant for damage is several only and is not joint.
Defendant? Is this a defendant, the fraudster? Is that, are they in the lawsuit?
But then it goes on, says each defendant is liable only for the amount of damages allocated to that defendant in direct proportion to the defendant's percentage of fault. And then it goes on in section B, which is where the word consider comes in. Right. In assessing percentage of fault, the trier of fact shall consider the fault of all persons who contributed to the alleged injury, death, or prior damage, regardless whether the person was or could have been named as a party. So the problem, Your Honor, is that that's what the statute says, and it's not there by accident.
Well, right. The word considers there is not there by accident. No, but the legislature could have said, it could have added a word or changed it and said, the jury shall apportion fault instead of consider, shall apportion the fault of all persons who contributed to alleged injury, regardless of whether the person was or could have been named. Right? Could have used that different word. And what is the authority for us to interpret consider as something more significant?
And the answer is to go to the very next paragraph that says, and I believe, with due respect, the court cut me off, because it says the relative degree of fault of the claimant, the relative degrees of all defendants and non-parties shall be determined and apportioned as a whole at one time by the trier of fact. So while it does, the word consider is there in the abstract, but the overall thrust of the statute is that the fault must be determined and apportioned. And the problem that we have here is that everyone at the trial, everybody in the briefs, everybody who's looked at the case knows that there is a non-party at fault. And that's the reason, Your Honor, that the non-party at fault rule exists as a subsidiary of 122506. Litigants are required to notify the other party of non-parties at fault.
So a jury, would you agree with me that it is a question of fact for the jury in apportioning fault?
Yes, I would agree with that, Your Honor.
And so here, let's say, and I'm not in the brain of the jurors, let's say they, as Judge House said earlier, they said, well, Arizona Escrow was hired to safekeep or usher funds through a process, and we're going to consider this fraudster across the Atlantic, wherever that fraudster is, and we've satisfied our statutory requirement, but we are still going to impose the full thrust of damages after considering that there was a fraudster involved, and that, at least this would be their argument, that your client didn't safekeep or protect whatever funds they left with you. Why isn't that precisely what the statute says? They're both considering that there's a fraudster and deciding, as a matter of fact finding, that the apportionment of fault should be entirely with your client.
Well, and first of all, Your Honor, because if you go down that road, what you end up with is something akin to the opposite of the last clear chance doctrine. That is, the last person in the chain of causation will always be liable. Because you can always say, well, yeah, there was a fraud committed, there was this person who was negligent, somebody else did something wrong, but you were the last person there, and if you had done your job, then the injury wouldn't have occurred. But
That's a question of fact. I'm not questioning what the jury did or didn't do. I'm saying, but you're saying they did something they shouldn't have done.
And if there is a question of fact, Your Honor, there has to be evidence to support it. There has to be some evidence.
Right.
And where
how about
a
evidence?
finding of fact is made that is not supported, that is contrary to not only the great weight of evidence, but all of the evidence in the record, then it is an abuse of discretion for the court, the trial court, not to set aside that finding. So what we have here is there is a massive amount of evidence. Throughout the record, there's a fraudster, there's a fraudster, there's a fraudster. And while the jury is entitled to exercise its discretion, the discretion of a jury in making findings and finding the facts is not unlimited. And where it runs into the end is where there is no evidence to support it. And the point, Your Honor, is that no reasonable juror could find that the fraudster was not at fault.
Okay, counsel, when you say, let's accept that what you call a fraudster, or what is called, had a role in this. If your client was retained to protect funds, and as a causal matter, causation, either there's zero damages or 97,000, depending upon if your client meets their contractual or professional responsibilities, why can't a jury consider the fault of this overseas fraudster, but still impose the full thrust of damages?
Because that's not what the statute says, Your Honor. This is a tort reform statute.
That's exactly what it says. Where does it say you have to apportion?
In subsection C.
So, counsel, right, I have counsel. I have that here in front of me. Let me ask you a question on this then. So, the instruction that went to the jury, the form of apportionment, there was three entities listed. There was Mago, your client, and the imposter, correct?
Yes, Your Honor.
So the jury is supposed to apportion fault among those three. Am I hearing you correctly that the jury was obligated to apportion some fault to all three?
No,
because all three were being considered?
No, Your Honor, and here's why. There's a difference. There was evidence in the record both ways on contributory fault of the plaintiff. There was evidence that the Magos were negligent and their negligence contributed, and there was evidence that they were not.
Okay.
Okay. As to the fraudster, there is no contrary evidence. You can ask Mr. Bueller. He will acknowledge there was a fraudster.
So let me ask you this then. Let me ask a couple of follow-up questions to this. At what percentage of apportionment would the jury have done its duty in apportioning fault to the imposter then? At 1%, at 20%? What were they obligated, duty-bound to apportion?
Your Honor, I will agree that is an issue of fact. I mean, what we think, we would have argued that it was a substantial portion. But that's not the case we have here. What we have here is a runaway jury that decided, even though they had uncontroverted evidence and an acknowledgement that a fraud was committed, they decided to take on one of two things. Either it's the last party in the chain, the last clear chance, or they decided that Arizona Escrow's liability was really bad because it was a fiduciary. But that's not the way the statute works. The statute doesn't allow the plaintiff to pin all the blame on defendant A simply because defendant A was really negligent or badly negligent.
Let me ask you a follow-up question to this then. Does the level of sophistication of the imposter determine whether a jury is obligated to apportion fault to them?
The level of sophistication.
Yeah, I'll give you an example. Let me explain what I mean. Let's say, so this imposter switched an M put an RN in the email in place of an M, correct?
Yes, Your Honor.
Okay. What if the imposter had written a handwritten note in crayon saying, here's the wiring instructions, and your client still wired it? And the jury said no apportionment of fault at all to this imposter. Would the jury been okay in that scenario?
No, Your Honor, but in that case, the liability of Arizona Escrow would have been clear. Because remember the way the case was tried. The point is that Mr. Mago didn't notice the change in the email address. Mr. Mago was the first person to deal with the imposter. Mr. Mago knew that his account had been hacked. Mr. Mago failed to tell Arizona Escrow that it had been attacked. Mr. Mago saw the instruction that says send this money to this account. Mr. Mago did not object and said thank you, Helen, to the escrow officer. So what you are describing, Your Honor, is a situation where the liability of Arizona Escrow would be much more clear. But that's not what we have. What we have is a situation where Arizona Escrow, in fact, acted in good faith, attempting to comply, and the escrow agent even went so far as to write an email to Mr. Mago, where he was copied, saying, "Is this really the account you want the money to go into?"
Which goes back to my point of if it seems to me that if you're going to carry your argument through, that subsection C of that statute requires the jury to apportion fault to every person it's considering, it had to also then apportion some fault to Mr. Mago.
No, Your Honor. Again, because if we were going to try the case from scratch, we would say yes. Juries, deference is due to the jury for its factual findings if the findings are supported by sufficient evidence. Okay, if we can agree with that. If the jury found that Arizona Escrow was liable and found that the Magos were not, I disagree with that finding, but I'm not here arguing that there was no contrary evidence. I can't make that argument in good faith. But by the same token, I can't accept in good faith the argument that the tortfeasor was not at fault.
Well, so let me ask you about that. Couldn't I have two related questions. And given this situation where part of the escrow agent's job is to make sure these kinds of things don't happen, couldn't the jury have recognized that and said, yes, the fraudster is on some level at fault, because of course he is, but given the nature of the relationship, the escrow agency should bear all the damages for that. And my related question is, would you still be here if the jury had said, okay, we assign 0.0001% fault to the fraudster? Then your argument goes away because the jury did consider and assess fault to the fraudster. And then to follow up with an earlier question, what percentage would have gotten the jury off the hook here?
Your Honor, I can't answer that question because it's hypothetical. It's not what happened. And the court is not called on today to decide what is the minimum amount of fault. We don't have that issue. We have zero. And zero cannot stand. There is no intellectually honest argument to be made that complies with the statute.
Would you be here today making your argument if the jury had said we assess 0.0001%? Would you be here?
Your Honor, I can't answer. It's hypothetical. If you want my personal opinion, I can give you a personal opinion. That would have been something we would have discussed. We would have talked to the client. We would have done research. Who knows what we would have done had that happened. But that did not happen.
Well, it's a perfectly fine question. If they awarded a penny does that make a difference as to whether you are I mean, are you making the same argument here? If you're not, why?
I don't know, Your Honor,
This
because
is
it's
Court of Appeal. We
hypothetical.
deal with
It's
the entire area.
No, but it's hypothetical, Your Honor. That would be the next step. I mean, the cases, I will say, the cases are really clear.
Well, in you mentioned Ogden, but Ogden, there's a stipulation of the parties that the driver was proximately responsible for caused the accident in Ogden. So it's a little bit factually different in Ogden, I think.
Agreed, Your Honor. The better case is Nate's Way versus City of Tempe. Okay, and that's the one where there was a car speeding down the freeway, and the City of Tempe failed to give notice to people that were in the way, that they were chasing this guy at 100 miles an hour. And the court found that, well, yeah, the City of Tempe could have prevented this from happening, even then had a duty to prevent it from happening, could have stopped this from happening by merely giving notice, and they didn't give notice. And yet the court says you still have to apportion fault to the people upstream. And it's literally upstream in that case. That's the problem with the argument that's being made, is that it's putting all of attaching so much importance to who was the last party, the party that had the ability to prevent the harm, and saying, well, isn't that enough? And I apologize, Your Honor, but that is not enough. The statute is crystal clear, and that the fault must be apportioned among all parties who are at fault, which in this case includes this unknown person who committed the fraud.
All right, well, thank you, counsel. If you want to wrap up, it looks like your time is out, so.
Your Honor,
Okay.
I will rest on the brief, other than I would like to, if possible, to have a minute or two to respond to arguments on this point.
Yeah, I mean, you're out of time, so I can't allow that unless your colleague would be amenable. But is there a cross appeal?
Well, I guess that was the only thing I would say.
All right, there is, so you'll come back. You have a cross appeal?
We do, Your Honor.
All right, so that's what you should, yeah. Okay, so I'll give you, a minute or two on the way back.
That's fine, Your Honor, thank you.
Okay, thanks, counsel.
And I'm happy to give him a minute or two, Your Honor. If that's what the...
Well, if there's a cross appeal, then I have no problem with it.
May it please the court and counsel, my name is Gordon Buehler. I'm here representing the Magos in the case, and handled the case at trial below as well, Your Honor.
Do you want to start with that, the statutory, really
Sure.
pure statutory interpretation issue?
Yes, well, I would. Although I will say this, and I put in my notes if I could get them. I don't think we need to speculate about what the jury may or may not have been thinking. I don't think that's necessary. Because I think, as I understand what the law is with regard to Ogden and other cases, is that if any evidence supports a finding, a jury verdict, then that verdict is going to be upheld. And the trial court went through, this issue obviously was raised in front of the trial court, and the trial court went through precisely that analysis. The idea that the statute requires, the statute requires apportionment. I guess the question I would have and present to counsel is, why don't we believe that's exactly what the jury did in this case? The jury did apportion, and it apportioned fault instead of three ways, which is what the escrow company wanted. The escrow company wanted the fault apportioned to the Magos, wanted fault apportioned and asked for that at trial, wanted fault apportioned to the imposter and asked for that at trial, and wanted fault, if any, against it. In fact, honestly, the escrow company denied any liability at trial and said, we are not at fault in this situation. If there had been a finding in favor of defendants that it was nowhere at fault, I don't know. I don't know that I would be arguing, well, the jury didn't apportion, because the jury would have apportioned under those circumstances, and actually apportioned under these circumstances. It just apportioned 100% fault.
Was there a verdict form?
There was, Your Honor, and
Did they write 100?
Yes, they said 100% fault at Arizona Escrow. And so, and again, I say that the analysis is whether evidence supports the jury's finding. If we read Ogden, it says expressly, and the other cases, Kramer and Saransky, there's also some, the cases cited by Arizona Escrow. But in Ogden, which is the principal case they relied upon, the court said this: we find no evidence to justify the jury's conclusion. We find no evidence. And to the contrary, the trial court in this case received the motion on apportionment and considered it. And this is what he said. Now, he said, with respect to, if I can quote him, this is in his transcript dated January 7th, 2022, that's provided with the court. He said, with respect to the second issue, which is apportionment of fault, I don't find the jury's apportionment was the result of passion or prejudice. So it wasn't the result of passion or prejudice. The question is whether there's evidence that would support a finding of 100% at fault on the part of Arizona Escrow.
So we have a jury instruction, and if this is right, and the court is saying, and then a verdict form that is inviting different numbers for the plaintiff and the defendant. What does Arizona law say as to whether or not we assume that jurors followed the jury instructions?
I do think that is, yes. I think the law in Arizona would be that we're going to, unless there is no evidence to justify a jury's finding,
is it no
we are going to
evidence
respect
or
that finding.
No reasonable evidence or no?
All I can do is quote Ogden, which has said there is no evidence that would support such a finding. That, again, I think that's where the state of the law is. That's certainly the state of the law that was relied upon by the trial judge, I think correctly, in that case.
So the fact finder here could have disagreed, in fact, I guess did disagree with the escrow agency's argument and believed that the escrow agency was wholly at fault for not protecting your client from the fraudster. That's not to say that the fraudster doesn't bear moral blame for doing what the fraudster did, but under the claim that your client brought, the fault lies with the whole fault lies with the escrow agency. So the jury did what the statute requires it to do.
Yes, I agree with that. And the idea that I know that the title company wants to, or the escrow company wants to say, well, this was just, we're the end of the chain and therefore the jury's putting the fault on us. I don't believe that. I think if we're going to speculate and think about what the jury's thinking about, I think they're thinking, wait a minute, and this is the evidence presented at the trial, who's the professional here? Who has the responsibility to safeguard these funds? We know that there are going to be bad guys out there that are going to be trying to intercept these funds. Who is charged with making sure that doesn't happen?
So does that mean that, I mean, it's almost like a causation type of argument, that if the title company here could have prevented the fraudster from being successful as a matter of causation, even under their job description, that they could be apportioned 100% fault? Is that the law, that we would look at causation that way in apportioning fault?
Well, I don't know that I would. I think, again, I get back to what I think the law is in Arizona, which is, does evidence support the jury's verdict? And again, as I was saying, I think the principles of causation and other things, leaving those aside, We're asking about a finding made by a jury and whether evidence supports that. The trial court said, well, at least two pieces of evidence can fully support and justify the apportionment of 100% fault against Arizona Escrow. Number one, Arizona Escrow sends out an email in January of 2017. I think it's 2017, it's 17 or 18. I mean, again, this is going back a while. And says, hey, this is to Mr. Mago. This is the president of Arizona Escrow. And he says, hey, Ricky, you did everything you were supposed to do. This is not your fight. We're going to make sure that you're made whole by giving you a credit at the close of escrow. Don't worry about it. And the jury, I think the jury considered that at trial, and the trial court said, yeah, of course, if the president of the company is going to come out and say, hey, Ricky, this is on us, that supports the jury finding. The second thing was, and the evidence at trial was very clear, and again, this is the trial court, when he examined this issue, he said, look, the evidence was very clear at trial that had a phone call been made, Arizona Escrow, if you will remember, looking at the briefs and some of the transcripts and the other arguments that were made, Arizona Escrow had contact information for the people that were to have received the funds. All they had to do was make a phone call. And the lady who was to receive the funds came into court and testified, hey, I've got my phone with me all the time. I keep my cell phone with me all the time. These are business people too. If someone had called me, this would have all have been avoided because I'd have said, we don't know what you're talking about. And so in other words, the trial court said, just to finish, Your Honor, I'm sorry. The trial court said, look, those pieces of evidence fully support the jury's finding in this case of 100% apportionment of fault.
Do you have any case, or what's your best case that would reflect that? So some sort of professional services agreement, lawyer, doctor, I don't know, fill in the blank.
Yeah, it's interesting, Your Honor. I don't know that I have a case. We did argue about the instruction because we argued for an instruction that would not allow the consideration of the non-party at fault in the trial. We said, look, in a fiduciary relationship case, we ought not to be instructing on non-parties at fault because our claim is not strictly a negligence claim, but a fiduciary duty claim, and obviously the imposter did not have a fiduciary duty or fiduciary obligation in the case. Our position was at least as regard to that issue, that we shouldn't have that kind of instruction. The court said, no, we're not going to do that. We're going to give the instruction. And in fact, I have a copy of the instruction that the court read, and it includes, and I think what the statute requires. When the statute says the jury is going to consider it, the jury is going to consider the arguments, the evidence, and also the instructions that are put to it with regard to consideration of fault.
On this statute, so yes. You're saying there was at least one jury instruction on UCADA, which is what, uniform contribution.
All of the, if I can find it, Your Honor, all of the, beg your pardon, sorry, Your Honor.
I mean, I'll find it.
All of the jury instructions were strictly Raji's and included all three parties listed, the Magos, the Arizona Escrow, and the imposter as parties to be considered for fault. And the jury form, the verdict form, had, again, the imposter listed as fulgurn.com. So the instruction was, and I think what the statute requires is consideration, not a number. As the court rightly points out, what would that be if they 1%, 10%? I mean, I don't believe that's a hypothetical question. I think that's a real question. What counsel is really saying is, under these circumstances, the jury cannot conclude 0%. But again, as the trial court found, and as I think the evidence supports, the jury had evidence before it that it could consider that.
Switch topics.
Sure.
Attorney's fees. The award of attorney's fees for $67,500. The fee amount requested was $66 and change. The amount awarded was $67 and change. Is that? Are you?
I was not clued in on that, Your Honor. I apologize. I don't believe that was raised in the briefing. If it was, I'd go with what we submitted. I mean, and if that's $1,000 less, again, I think fees are amply justified in this kind of a case. If my number is wrong, if what we submitted is wrong, I'm happy to. You can send it back to the court for that.
Right, not on reasonableness, but on entitlement, 34101. When does that allow for a fee shift in a tort claim?
Yeah, well, again, Your Honor, I've got a separate packet for that. If one looks at the Maxfield versus Martin case, I think it's a case that bears in many respects on exactly what happened in this case. The court said, after talking about the duty of the escrow company to properly identify the recipient of funds, it said Maxfield requested an award of fees pursuant to the contract statute 34101, which permits this court to award attorney's fees to the successful party. As the case is not yet concluded, we decline to award fees at this time. In other words, again, I think the fact pattern in that case and this case are very, very similar. I say that because the fact pattern in Maxfield versus Martin it included a woman who was not even party to the escrow instructions. Her property information had been forged and included as in an attempt to grab her property and money related to her property. She was not even party to the escrow instructions. She sued, and the court said, hey, look, you got an escrow. This woman's name is appearing in the escrow as it must because she is the property owner. It's true that she wasn't a party to that contract, but her fiduciary duty claim should provide for an award of her attorney's fees.
Your tort claim would not exist but for the contractual relationship.
How could it? And again, I think the Arizona law is very clear on that. It does get frustrating because there's two cases that are precisely on point with regard to this issue. When I say precisely on point, Maxfield versus Martin did not include an award because the case had not been concluded. But there are other cases that this court has decided. I can give you the sites that are non-published that are precisely that issue.
Counselor, can we move on to your cross appeal?
Yes.
I understand the award of $79,000, but I don't understand where the $300,000 came from.
Well, Your Honor, the award, what we believe is a showing by the jury of the frustration with Arizona escrow. And as the trial court properly pointed out, he could see some of the problems with the actions of Arizona escrow that might have allowed the jury to award the additional money above the $79,000.
What evidence is there in the record that your client suffered the additional $300,000 in damages?
Right. Well, I will point out that we did not argue, before I answer your question, Your Honor, I will point out that we did not argue for lost profits or anything like it after the court made its determination relatively early on in the trial that it wasn't going to allow a finding or a showing of lost profit. There was no argument made about that. But the instruction says, look, the jury is going to find what is the appropriate amount of that. And I do know our client testified about the costs that he's incurred. He had to borrow some money. He had to pay a high interest rate. How it rounded up to $300,000, Your Honor, I don't have that. But I do believe that's within the purview of what the jury was instructed to find, which is the full amount of the money. And I could read the instruction, but the full amount of the money, again, it's the Raji instruction that would bring the plaintiffs back into the position where they were.
Well, I mean, what evidence in the record is there that there were other costs that your client had to bear and what those costs were?
There's nothing in the record with regard to the specific costs. Our client did testify about additional borrowing costs but he did not put, he used a percentage rate, but he did not put a dollar. In other words, he didn't say this cost me $50,000 or $100,000. He did not testify about that, Your Honor. Okay. And so if that's the answer to your Honor's question, that's the best I can do.
Okay, thank you.
Unless the court has, I've got 2.5 minutes. I'm happy to beat the air if the court wants me to, but I'm also happy to rest on what is before the court by way of briefing and argument.
I appreciate your argument, counsel. Can you put 2 minutes back on the clock? Mr. Cohen.
Thank you, Your Honor. Very quickly, Your Honor, let me start with the Ogden case, which is controlling. In Ogden, there were two defendants, or a defendant and a non-party, and the pickup driver driven by Lichtman collided with a motorcycle driven by Zeller. Zeller died, Ogden suffered injuries. Then the Lichtman was intoxicated. He was the motorcycle driver, and he was driving a motorcycle owned by his employer, Steele, but there was no joint and several liability. So the jury comes back, and Lichtman was designated as a non-party at fault. Jury comes back with a verdict in favor of plaintiffs and against Steele, allocating 100% of the fault to Steele and no part of Lichtman.
But
That means that
the parties there had stipulated that the truck driver was proximately caused the accident. There was a stipulation by the parties that a non-party at fault bore responsibility.
Well, but Your Honor, but the answer is what the court found, though, there was no evidence to justify the jury's conclusion that Steele was wholly at fault, but Lichtman was not at fault. That's exactly what went on here. Whether they stipulated or not, there was comment after comment after comment during the trial that the fraudster committed the fraud, the hacker committed the fraud, the hacker hacked into the email, the hacker sent the instruction. It's a distinction without a difference, Your Honor. How can you say that the hacker did all these things but was not at fault? Other than that, the trial court says no passion or prejudice, but there's no evidence. It's just speculation. On attorney's fees, this was tried as a tort action. It's distinguishable from Birkins and the other cases where there were tort and contract actions. And if the court will recall, Arizona Escrow prevailed on the contract claim when this case first came up on appeal. But the answer to the main question is that the statute says fault must be apportioned. And what we're looking for are reasons to get around that, and that's not the right question. If we assume that Arizona Escrow was at fault, it breached a fiduciary duty, that was one aspect, but so was the fault of the fraudster. The fraudster had to have some part of the liability. Thank you, Your Honor.
Thank you, Mr. Cohen, and thank you, Mr. Bureau. Thank you both for your helpful arguments. We will take it under advisement, have a decision out in due course, and with that, we are adjourned.